Hello, everyone. I am Martin Willemse. Welcome to the Disability Law Question and Answer session. I'm a partner at the firm of Samfiru, Tumarkin, and the Western Canada Disability Practice Leader. I welcome everybody, and we welcome your questions on our live forum. One of the things that we are going to discuss today, that I wanted to discuss today, is in the season of layoffs, as these seem to be carrying on and continuing with a possible recession coming our way. Many questions arise as to what will happen with people who are already on long-term disability. In other words, that they are already receiving LTD benefits, but are still employed by their employers. What will happen to their claims if during a disability claim, which is active, their employment is terminated? We get this question regularly because obviously there's a concern for people that if they were to recover from their disability and they wanted to go back to work, what will happen, and will they continue to receive their benefits if their employment is terminated? So what I will say is this: if your claim vested, in other words, if you became disabled while you were employed and you are receiving long-term disability benefits, you're receiving that most likely from an insurance company. In those situations, it doesn't matter that your employment is terminated with respect to the ongoing receipt of long-term disability benefits. Your claim vested while you had coverage. That is the most important thing. In order to receive long-term disability benefits or to qualify for long-term disability benefits, we would want to know, or you would want to know, that you do have coverage. And the way to do that is if you are actively employed. So if you did receive benefits, or if you became disabled while still employed, while working actively, going to the office or wherever you would be working, you became disabled then, started to receive benefits, and a year later your employment is terminated, that should not affect your ongoing entitlement to long-term disability benefits other than other provisions in the policy. So there should be no concern with that. And if your employment were to be terminated and you wanted to return to work when you're better, there is a possibility that there may be a claim against the employer, and we would invite you to contact our firm because we also handle disability employment matters throughout British Columbia, Alberta, and Ontario. And you can contact us to find out more, as you can see on the screen, at disabilityrights.ca. Another question that comes up regularly is, what are the most common reasons why insurance companies deny disability claims? Again, this is a very common question, and it's always good to have responses to this as to why, so you can understand what your rights are and what to look out for. When you go on claim with an insurance company, you have to look at the reason for disability and get the proper evidence in place from the doctor and from yourself. I'll go back to that in a moment because we do have a question from Melinda. If I start renting out my basement apartment, would that be considered income and impact my disability payments? Great question, and it's another one that we get frequently. Your entitlement to LTD benefits is based on you proving that you are unable to perform the essential duties of your occupation. Certain offsets are applicable based on whatever is stated in the group policy. The most likely ones that you would see is if you were to be entitled to CPP disability benefits, which is funded by the federal government or paid by the federal government, that would be what is called a direct offset. There may also be benefits paid by WCB, which may be a direct offset. And then there are indirect offsets. For example, pensions that you may receive, severance that may be paid. As it turns to renting out your basement, if there is no employment involved in that, literally you have a house and you're renting out your basement, you have a tenant, they're doing all their own work, there should be no reason why that should be an offset, as offsets, in other words, monies that are deducted from LTD benefits, are all based on some form of employment activity. For example, CPP is different because that's another benefit that you're receiving because you made contributions while you were working. Same thing with WCB, same thing with the severance. So things like if somebody gets an inheritance, or if they have active stocks and they're receiving some dividends from that, none of those things, like like rent that you're receiving from renting out your basement, would be an offset. It would be an entirely different thing, though, if you had multiple properties that you are renting out and you're actively going out to do property management, to do repairs, things like that, because that may indicate function and that may indicate some form of employment income. But renting out your basement as a sole issue, I don't see that as an offset, and I don't see that as any reason to affect your disability benefits. Question: why does LTD want my CPP denial letter? Can they force me to send it in, and will they cut me off if I do not? It's a good question. Most policies will provide, and I'm speaking about group policies that you may have through your employer, they may provide that, or they likely will, that CPP disability benefits, as I've just said previously to the response to Melinda's question, those benefits are offsets. In other words, it can be deducted by the insurance company. And most policies also say that you must apply. If you're eligible, you should apply for CPP disability benefits. And if you don't apply, the insurance company can estimate the amount of the benefit which they believe you would have been eligible for and may deduct that from the benefit itself. So should you be providing your LTD letter to the insurance company? I don't think the policies actually provide for that. What you may want to do is appeal that decision. And if it is denied, then I think you've done everything that you could. There may be a further level of appeal, but the policy itself, I don't believe provides that you have to provide the letter. But ultimately, I suppose the claim was denied because the Insurance or Service Canada did not find that the disability was severe and prolonged. There may be other reasons why it may be denied, for example, that you did not have enough contributions, but the vast majority of cases when you deal with CPP disability benefits are denied because the government finds that the condition is not severe and prolonged. Of course, you can appeal that by getting better evidence from your physicians to assist you with that appeal. What you have to prove is, number one, the condition is severe. Number two, it is prolonged. And number three, most importantly, that it prevents you from engaging in any gainful occupation. That is the actual test for CPP disability benefits. If there are other treatments available which you have not yet tried, cases in those instances may be denied as well. So have the doctor speak about the nature of the disability, that it is severe and prolonged, that you cannot work in any gainful occupation, that you've been actively involved in treatment, and that there basically may not be other treatments available to you. If the prognosis is poor or guarded, the chances of it being approved would be higher. If the prognosis is good, then Service Canada may look at that it is not a prolonged disability. We've got a question from Night. Hi, thanks for your time to answer our questions. I'm LTD from Manulife, and I asked my employer to go back. They say not now because they are not busy yet. My question is it okay to work with Uber? Following question, can Uber know if I'm working for Uber and they cut the payment? Can Uber know? I'm sure that, meaning your employer. So the issue with disability benefits, for the first, if your policy has two different definitions, which it likely has, the first one will be that you have to prove that you cannot perform the duties of your own occupation, the essential duties of your own occupation. For the most part, that would be for the first 2 years. Some policies may provide that it's for 1 year, and other policies may provide that it is for 2 years or even longer. During that period of time, you have to prove that you cannot perform the duties of your own occupation. Now, the important feature here is the issue is not whether you can perform the duties of your own occupation for your own employer, because that's your own job. The insurance company will be looking at, are you able to work in your own occupation? If you did go back to work for somebody else because your employer is saying that they're not busy enough, it depends on your capacity. If you're saying that you want to do a gradual return to work in something else, like doing an Uber position, which I suppose you're going to be sitting for long periods of time and driving people around, the insurance company should know about that. Because if you go and you return to work for somebody else and the insurance company is not aware of it, they may look at that as you not being straightforward and upfront with them that you have returned to work. So I would be, in your situation, upfront with the insurance company and say to them, this is what I'm thinking of. But be very careful here. Make sure that you have your doctor on board, that you are able to return to work, and probably in a very graduated basis. If your doctor thinks that accommodations should be in place and limitations, have the doctor commit that to writing and communicate to the insurance company that is the situation. Because if you did return to work and the insurance company was not aware of it, then I think you're going to be running into trouble. Remember, the insurance company is focused on getting you back to work. And they're going to be focused on the fact that you're going back to work may indicate that there's improved function, which clearly there may be if you feel that you can go back to work. Look at how long you're doing it, because if it's during the own occupation period, you're not doing your own job, you're doing something else. So maybe the insurance company could even look into providing some form of rehab to assist you in going back to work. But the moment that you find, if this does happen, that you're unable to do so while you're doing the graduated return to work, if your symptoms increase or if you have a relapse, make sure to report that to your doctor and follow your doctor's advice if the doctor recommends that you go off work again. So be careful, and I always recommend to everyone, if there is a return to work in the cards, in other words, you're doing or you're taking positive steps to get better and to try to get back into the workforce, during this time frame, make sure that you see your doctor on a regular basis, because if there's any worsening, you want to have a paper trail that you reported this to the doctor. How they will know if I'm working with Uber? Well, I cannot say to you how they will know, but if you, I can say this to you, if you are working for an insurance for somebody else and you haven't reported to the insurance company and they do find out about it, well, I expect that there may be some concerns later on. My advice, at least to anybody, would be upfront if you're doing something like that, because being honest in these cases, I think, is the better way to deal with things. You're welcome. Going back to common reasons for insurance companies to deny cases, one of the most common ones would be that there is insufficient medical evidence or evidence to support that the person is unable to perform the duties of their own occupation or any other occupation when it gets to the change of definition. How do you deal with that? When you submit your evidence as part of the application process, you have to submit three things. The first one is your own application. It's called a plan member statement for the most part. The other one is called an attending physician statement, which is completed by either your family physician or it may be by a specialist. And the third one is a plan sponsor. So that's completed by your employer. When your doctor completes the forms, make sure that your doctor gives details as to why it is that you cannot work. Quite often people would say to me, my doctor says I have depression, but the insurance company denied my claim. Many people do work with depression. The question is, why are you unable to perform the duties of your occupation? Not because of the diagnosis of depression, but because of the restrictions and the limitations that you have as a result of the diagnosis of depression. For example, if you work in a bank as a teller, but you have been diagnosed with a panic disorder or depression and anxiety, which often go hand in hand, the doctor may want to say, if this is the case, that you have an inability to work with the public, that you suffer from panic attacks, that you have an inability to focus, poor concentration, poor ability to multitask, that you oversleep, that you have a low mood, that you may have anger outbursts, etc., fatigue. All of those things would explain why it is that you cannot work. So make sure that you have the evidence in place. If you have a mental health condition that requires medication, make sure that the doctor details that and what medications you are taking on, and consider having your doctor refer you to a psychologist or other treatment provider which may provide some counseling, like a therapist or a counselor, so that you can explain why it is that you cannot work. As I say, many people with depression or anxiety do work, and same thing with chronic pain, same thing with fibromyalgia and chronic fatigue syndrome. It needs to be explained why in your situation you cannot work. We've got a question from Thunder Nerve. I'm still under WSIB treatment and modified duty, but it not make my condition better. What is my right to request medication outside country for 2 months? Can I, and what law can I apply? So in terms of WCB cases, I cannot speak about what WCB would be providing you with respect to an insurance company. If the insurance company is also paying you, the insurance company does not have to fund treatment, but they often will do so in a case if they believe that it is in their interest to do so. For example, like we're saying with anxiety and depression, the insurance company may decide that they want to fund some treatment for you to go to a psychologist to do some sessions, with the expectation that at the end there will be an opinion that you can do a graduate return to work. So policies, LTD policies, do not provide that the insurance company has to fund treatment, but they may do so out of their own will if it is cost effective to them. In other words, that they think that the time or the money spent on funding treatment would be less than if you did not go through that, and you would be on claim for a longer period of time. Miranda says, my sister has been diagnosed with rheumatoid arthritis. Would this be considered an existing condition, or could she receive LTD for this when it gets worse? Rheumatoid arthritis is a disability. Well, it is a condition that can lead to disability, because I've seen many cases where people do have rheumatoid arthritis. I'm not quite sure what it means when you say if it's an existing condition, if you mean that it's a pre-existing condition. If you have been diagnosed with the condition of rheumatoid arthritis or any other condition, it may not be that you're unable to work at that time. Like I was saying, people with depression may work, people with other conditions may work. If she is diagnosed and it is the opinion of the doctor and your sister that she cannot work at that time, she probably should apply. If it is that she's been diagnosed with this condition, but she can still carry on working, be sure that she sees her doctor on a regular basis so that it is monitored. If she were to go off work, if she does get worse, then she can go off work, but make sure that all her complaints are documented by the doctor. This is very important. When somebody has been diagnosed with a condition and they're still working, but they go off work maybe a year or a few months later, the insurance company may say, well, you've been diagnosed with this condition. We want to know why it is that only a year later you went off of work. What changed? So you want a paper trail to report to the doctor if there were to be changes and if things were to be done, that it gets worse. The only other issue that may come up is if it is a pre-existing condition, and that would be, what does the contract provide is a pre-existing condition? The contract will provide, if something is a pre-existing condition, if the person has been insured for less than a year. In other words, if they go off work, so they get the insurance in January, and they go in January of 2023, and they go off in June of 2023, then they've been insured for less than 1 year. But the condition has forced them to go off work. Then the insurance company can investigate whether it is a pre-existing condition within the meaning of the policy. What that means is, and we speak about this so often, the phrase pre-existing condition seems obvious in layman's terms or in medical terms, but it's not the same when you get to a disability policy. It's a contract. So you have to consider, what does that mean? Pre-existing conditions in contractual terms may provide that if you had treatment for the disabling condition or for an injury or an illness that led to the disability during a very defined period of time, then it's deemed to be pre-existing. I will use the example of rheumatoid arthritis. If it arose 5 years ago and you've only had coverage now for the past 6 months and you've had active treatment all along, the insurance company, depending on the language of the policy, may look at whether the 90 days before the insurance coverage, were you being treated for that? Say, for example, you were diagnosed with rheumatoid arthritis 5 years ago and you've had treatment on and off. And there were to be a time frame, and maybe this specific time frame, that you did not have treatment. It may be that the rheumatoid arthritis will not be deemed to be a pre-existing condition based on the contractual language. Even though it clearly is a pre-existing condition in other terms, you need to see whether it is pre-existing in terms of the contract. And that's why in cases like this, especially if there's a pre-existing condition, you want to reach out to us so that we can review your policy, that we can review the denial letter and the medical evidence. I speak to people with denied pre-existing condition claims on a weekly basis, and quite often there is an argument to be brought that it is not pre-existing within the meaning of the policy. And again, you can go to our screen there and contact us. You can go to disabilityrights.ca if you have any further questions. We were unsure what it meant for pre-existing condition because it's a genetic condition, so she technically had this in the genes. The consideration of whether it is pre-existing, as I've just said, is it a pre-existing condition within the meaning of the policy, which is a contract? If your sister has had coverage for more than a year under this policy, it should not be deemed to be a pre-existing condition because the insurance company cannot really investigate whether it is. It all depends on what it says in the policy, but for the vast majority of them, if you had coverage, say you had coverage for January 2023 and you go off work in May of 2024, you've had coverage for more than a year. So even if it had been pre-existing, if you have had it for your whole life, it should not be a consideration if the policy provides that the pre-existing condition exclusion only applies to the first year of having coverage. If there are more questions and if your sister is concerned about whether it may be pre-existing, she's very welcome to reach out to us. We can look at the wording of the policy and see whether we think that it would be pre-existing. But again, if she's been insured for more than a year, it should not be a concern. Going back to other reasons why insurance cases may be denied, another one that we quite often see is that the person is not being appropriately treated for the condition. What insurance companies often do is they may look at what treatment is being implemented. For example, if I speak about mental health conditions again, you have a doctor who is treating you and has prescribed certain medications, and you've been on the same medication for 2 years, and the dosage has remained the same. The insurance company may look at that and say, well, we don't think that you are disabled and that you're being appropriately treated because our doctors, our internal health partners, have looked at the claim, and their opinion may be the following. You have not been appropriately treated because you've been on the same medication for 2 years at the same dosage. It hasn't provided any benefit. There's no improvement. Why have you not been trialed on other medications, in other words, antidepressants of other makes or other generic types? Why have you not been referred to a psychiatrist? And why have you not been referred to a psychologist? Why are you not doing counseling? So those are ones that we often see. Of course, every case is so individual. There may be reasons why that hasn't happened. It may be that the person is refractory to treatment. It may be that they've tried different medications earlier, and this happens quite a lot. Certain people are extremely sensitive to medications. For example, antidepressants, which may have the opposite effect. Some people may become suicidal, even homicidal. Others may have very bad side effects. Others may feel that they are feeling like zombies, I've heard in cases. So there may be reasons as to why medications are no longer being implemented as treatment because the person has exhausted all of those options. Remember, when an insurance company denies a claim, they often have their own doctors look at why, or if there is a reason why they would think that the person is not disabled, and it may be that they think that the person has not been properly treated, or the restrictions and limitations of this condition may not prevent them from performing the duties of their own occupation. And these doctors, when they give these opinions, would quite often be contrary opinions to the opinions of the doctors treating the person who's making the claim in the very first instance. The doctors the insurance companies use to give these opinions as file reviews would not have even met, seen, or even spoken with the person over the phone, yet they feel that they are qualified in a position to deny a person their claim, where a treating doctor who would have had the benefit of treating the person for a long period of time would have seen whether there's been any relapse or regression in their condition and would have had the benefit of assessing whether the person is actually disabled. Those opinions, I would say, are valid. So if there is a denial because the insurance company says our health partner or our doctor has looked at this and doesn't think that you're disabled, again, reach out to us. These are cases that we often assist with, and we can help by providing you at least an informed opinion as to what your options are. Question from Reggie. I would like to move closer to the hospital so that I can have easier access to my treatments, but my insurance company is through my employer. Would my insurance be in jeopardy if I moved? I don't think, if you're moving closer to your hospital, I mean, if the hospital is fairly local, I don't see how that would be an issue at all. It would actually be, I think, be deemed to be a good thing. Your insurance should not be affected if you move to be closer to the hospital, unless we're speaking about you moving provinces, because insurance companies may look at that to say, well, now you've moved away from where your employer is, so clearly you're not planning on going back to that employer. But even in those instances, it should not affect your disability entitlement. I have seen cases where insurance companies have used that as a reason to deny a person's claim, where they would say, well, clearly you have other reasons why you're not working. You were motivated to move away, so that is another indication to us that you have no desire or motivation to return to your own occupation with your employer. But there are reasons why people do things. I have seen cases where people would have, I can think of one now, for example, if you have multiple sclerosis, where the person may have needed family help, there was no family in that province. All the family was in a different province. So the person moved away to be closer to family so that they can provide assistance because the person was quite disabled from performing their activities of daily living. That should not be deemed to be a reason to deny a claim. So if you move closer to your hospital, I cannot imagine why that would be a reason to jeopardize your insurance, unless it's out of the country, for example, which is a whole nother discussion as to why you should probably be in communication with the insurance company about that. But moving to the hospital or closer to the hospital, I don't see that as an issue. I'm on LTD for almost 2 years. This is a question from Mark. I'm on LTD for almost 2 years. I have been assigned a new adjuster who is pushing for me to start another round of physio and get on a return to work program. I went through physio previously and attempted a return to work, but it didn't work and made my condition worse. What can I do? Great question. So we often see this happen when a new case manager is appointed at the insurance company, and this new case manager may be very overzealous to try and get the person back to work and may be looking at it differently. So if you've done physiotherapy before and it worsened your condition, I'm sure that you were speaking to your doctor when that did happen. So if this is now being suggested as another form of treatment, coupled with a return to work program, I would strongly suggest that you go and have a discussion with your doctor. If your doctor disagrees with the insurance company's plan, have the doctor put that in writing. Why would your engagement in a physiotherapy program coupled with a return to work program be detrimental to your health? And why does it carry the risk of your condition getting worse? The doctor can put that in writing and refer to the previous experience that you had as to what happened there and how that aggravated your condition, and use that as confirmation as to why it is that probably is not a good idea for you to engage in this treatment program and what the risks are. Because the last thing that you do want is for you to attend in this program and your condition to get worse as it did the previous time. So my advice would be follow your doctor's advice, but it is absolutely crucial that your doctor is on board. You will hear me speak throughout. You've heard me speak throughout this session. It is crucial to have doctors on board when you deal with disability claims in a situation like this, where an insurance company may be pushing you to do something which may be negative in terms of improvement and your actual health, that it may result in a relapse or a setback or a worsening. That obviously is not what the insurance company wants either, and that's not what you want. So make sure that you have your doctor on board. If you see a specialist, get the specialist on board as well. Have them write letters, send it into the insurance company, say, my doctor is advising that I not participate in this program, and these are the reasons why. And if the insurance company is still pushing you to do so, and if they were to deny your claim because you didn't, be in touch with us, because we definitely can assist in a situation like that. These are cases that come up regularly, and people quite often feel that they are compelled to do so, to participate in these programs, when in actual effect, it may not be the case where it will be helpful to them. Again, contact us to find out more at disabilityrights.ca. There's a lot of questions on there that you can see at our website as well. We practice throughout BC, Alberta, and Ontario. If you've got any questions related to disability claims, critical illness, or life insurance, we can assist with those. Our next session will be on February the 8th at 1 p.m. 1 Pacific Standard Time on employment Q&A, and that would be with founding partner Lior Samfiru. And that would be this coming Wednesday, live at 1 p.m. Eastern Standard Time. Thank you. We appreciate your feedback and the questions, and join us next time. Have a good day.